I've been invited to present about data privacy and protection in the year ahead. What do you need to know? So without further ado, this is what I hope to present. Basic definitions, what is privacy and why it is important. A little bit about the difference between data security and data privacy, especially for the technical group in the room. You really want to be clear about those differences because privacy and security are not the same. Of course, there's some overlaps. Basic terminologies, the key actors within the privacy space. We'll introduce some data protection principles and how to be compliant. So that's what my short presentation will be about. So when it comes to privacy, the best definition is usually the simplest one. We talk about the right to be left alone. So when you get off the highway, maybe you're driving to your house, as soon as you get away from the public space, you don't expect all the people that you are with in the public space to follow you into the sitting room. So that's privacy. It's sort of guaranteed and understood by everybody. But the trick now is that technology has tended to erode that. Even now I'm streaming from my home. It means that my service provider, wherever they are seated, have a capability to see my home. Essentially, they have invaded my home through technology. So that's the whole rationale around Data Protection Act, to make sure that as we increasingly become automated, we still don't lose the right to privacy as enshrined in the Article 31 of our 2010 Constitution. So the Data Protection Act basically operationalized that Article 31. Why does data privacy matter? Or data protection? I use it interchangeably, but the lawyers will split the hairs and say there are slight differences, whereby protection is more on the security, safety side of it, while the privacy leans towards the data rights. But in general, I personally use them interchangeably. And data protection is important for enterprises because of the compliance steps one needs to follow, by the end of which their organization should be in a better place than before. For example, there's a requirement to do something called data mapping. Take an inventory of all your data stores, data sets, figure out who has access to them, what are the rights or privileges you've allowed them to have on those data sets, figure out if there are third parties downstream that you're sharing that data with. So that's all about data maps. Once you've done the data maps, you may surprise yourself and discover that there are some processes that you really don't need, or there are some processes that don't add value to your organization. So in the process of complying, you actually can cut costs. The other requirement is data protection impact assessment. If you're collecting personal data, the Data Protection Act requires that for high-risk processes, you need to do what we call privacy impact assessment. So in this case, you look at the risks that that process presents to your customers. I happen to have sat on the Data Protection Task Force that put together the Act, and what was clear to me was that we wrote the Constitution in 2010. We had envisioned having this Act, post 2010, probably 2011, probably 2012, probably 2013, but we didn't have it up to late 2019. Why? There was an economic push from Europe. Europe had revised its data protection laws and made it sort of difficult for enterprises in Europe to engage with enterprises in Africa, for example, that don't have the privacy laws. So as a country, Kenya, we didn't want potential trade that would have come to Kenya to go to Ghana or South Africa or Senegal, because those three countries have had a privacy law for over the last 7 years and above. So we had to get our acts together so that we are also visible in that space and don't lose out on the business opportunity. Now, non-compliance is costly. So if you don't believe that you're incentivized to comply with the reasons I've given, we have a data protection commissioner's office that can slap fines for non-compliance. Already, I think she had issued some fine to one of the players, I think early this year, for violations. She has also issued warnings to the data, the mobile lenders, and I think some hospitals. So the terrain has changed. You know, this year we're going to see more and more actions around non-compliance, but more importantly, awareness also from the data commissioner's office, whereby your customers are going to be increasingly aware of their data rights in this particular space. We'll discuss data rights in a moment. Difference between data privacy and security. Security is your typical IT stuff, firewalls, login credentials, backup strategies, encryptions. That continues to be important, while privacy is more on your customer perspective. What are her data rights? The right to know, for example, what data you've collected around her. She has that right inscribed in the Act. She has a right to be forgotten. For example, if she unsubscribes from a social media platform, she doesn't expect her data sets to remain on those servers. Those are her rights, and she can demand for them. You can imagine if you've gotten annoyed with one online taxi, and so you delete the app, it doesn't mean the online taxi has forgotten about you. It's your right that they do forget about you. So you can push as a data subject or as a citizen to ensure that that app you unsubscribed from actually deletes your data. Another privacy right is about accessing to see what you have collected about me. I know in Kenya we have some shops or some supermarkets that give you a loyalty card, but they never share the data with you. You just give them the details, and when you're buying stuff, they tell you what is your mobile phone. Then they sell you. But when you get home, you have no records of what you bought. You have no records of where they're storing that data. You have no records of the goods price, all those details about that transaction. The shopkeepers, the supermarket have it. You as a data subject or as a citizen of Kenya, you have no clue. It's a black spot for you. So it's your right to access data sets that people have collected about you. And I put supermarkets here, but it could be anybody else. Banks, mobile lenders, online taxis, educational institutions. We are notorious for not giving students their transcripts in good time. We are all affected by this new act. Actually, it's not new, it's now 3 years old. In terms of basic terminologies, we have definitions: personal data versus sensitive data. Personal data is any data set that can identify an individual. So things like my name, my telephone number, my email, those are my identities, or bits of data put together can identify me. With technology, even my typing speed. When I visit a website, there are tools that can sense my typing speed to be different from my neighbor's typing speed, and they can figure out a unique signature typing speed for individuals. That is also my personal data, biometric in nature. Sensitive data is personal data, but requiring more protection. For example, things like sexual orientation. In these parts of the world, depending on your sexual orientation, it can be a life or death affair. So that's sensitive to the extent that it can cause you harm if in the wrong hands. Health data is also sensitive. If somebody knows you have a terminal disease, they can begin to discriminate against you. So the Act expects that whoever is collecting sensitive data is providing additional technical and organizational protection around that data. In terms of the key actors, there are three main actors: data controllers, data subjects, and data processors. So data controllers are basically your business enterprise. Data subjects are your customers. Data processors are your third-party players. Best example is Safaricom relationship with their kiosks, their M-Pesa kiosks. So the people who sell SIM cards for Safaricom or who transact on behalf of Safaricom will be data processors, and Safaricom the data controller. So anybody you subcontract to handle your customer data is a data processor. And all the three actors have obligations within the Act. I just want to go through the key sections of the Act. We have about 52 pages of it, but the key areas include the principles of data protection. I'll go through that in the next slide. The rights of Wanjiku, called data subject. What are her rights? She has a right to consent to data you're collecting. She has a right to be forgotten. She has a right to human review. In the event some of us are using AI in their business processes, when the AI makes a wrong decision, Wanjiku has a right to understand, or for you as the owner of the AI module to explain why such a decision was arrived at. The obligations of data controllers include things like you must be registered. Okay, so if you're collecting personal data, the Data Commissioner Office needs to be aware that you're doing so. So she'll expect you to explain why you're collecting data, how you're collecting it, and among other details. There's the thing about cross-border transfers. Ideally, all your data sets are supposed to be in territory, but if it so requires that you, for example, have remote backups in another territory, then you need to ensure that the remote territory is, has adequate privacy laws. So you cannot save your data sets in a country like Somalia. You cannot save your data sets like in a country like Sudan. I'm just picking countries that are yet to enact this act. The Kenyan Data Commissioner will not allow, or if she finds out, you'll be in violation. So institutional page, there's a whole section on the Data Commissioner's Office, her roles, functions, and powers. The Data Commissioner's Office has, in recent past, published several supplementary legislations or regulations. So they break down the General Act into finer details for implementation. So general regulations, complaints and handling specifies how Wanjiku can complain against your organizations. Registration processes are outlined. The key data protection principles include fairness. In other words, as an enterprise, you need to be fair to your customers. Give them an opportunity to understand what data you're collecting, why you're collecting, and how you're collecting it. So fairness and transparency go together. For you to be fair, you need to be transparent. You need to give me an opportunity to understand, including your third parties. Who are you going to share my data with and why? There's a principle of purpose limitation where if you collected my data to provide me a service, for example, a taxi ride, an online taxi ride, I don't expect the driver to start calling me to for example, support them in some medical harambe, because the number they have access to is for dropping it to the office. They cannot then repurpose it and start, making me join their funeral arrangements or whatever challenges they may be having. Data minimization, simplest example, you download an app for mobile lending, but behind the scenes, as you install the app, it's harvesting like all your address books, contacts. So the day you stop or you miss a deadline to pay, they start calling your aunt, your uncle, and grandmother. They violated the data minimization principle. There's a storage limitation. How long do they keep your data? You left a particular company 10 years ago. Why are they still keeping your data? Why are they still sending you blank invoices, for example? So the Act comes to clear that gap and say you cannot keep data longer than the purpose prescribed. Factual accuracy. So if you collect data about me, you need to keep it up to date. So if you knew I was living in Rongai, but I have since moved to Runda, and your records still show I'm in Rongai, then there's a violation there. Of course, as an enterprise, you cannot know where everybody has relocated to, but you need to facilitate those people to alert you when they move. Because if you don't have an interface for me to update you about my data sets, for me to check what you know about me so that I can correct you, then there's nothing I can do to assist you to achieve this particular principle. Confidentiality is traditional IT security. And finally, accountability. This we must report to the Data Commissioner's Office, as I shall explain in the next slides about registration. So registration page on the odpc.government.go.ke was open from last year, June. So all data controllers must register, including data processors. Not everybody needs an in-house data protection officer, but the function must be there. So find out if legal can be trained to take over that role. Find out if IT can be trained to take over that role. Or in some cases, the risk guys have also been quite good in this particular function. Additionally, you don't need a resident DPO. You can outsource the function. The Act allows you to have one DPO managing maybe 5 or 6 companies. I'd mentioned the steps, data mapping. You need to do that to be compliant. It will outline the processing systems you have. You'll do an impact assessment. You should have a privacy policy to communicate the details of your data processing. Take note of automated processing. This is AI. There's a clause in the Act that says if you're using AI logic, there are certain things you need to put in place. If you don't, you'll be in violation. And finally, the breach. Whenever a breach occurs, because it will, even US Department of Defense gets hacked. So what makes you think your company won't be hacked? So the issue is not that you'll never be hacked, but the issue is, do you have processes in place to restore service and then alert the data commissioner? These are the registration fees. They range from 4,000 to 40,000, depending on the size of your organization, renewable every 2 years. I believe that is the end of my presentation.